Former President Trump invoked his Fifth Amendment rights today, declining to answer questions from New York's Attorney General. His deposition relates to the AG's long-running civil investigation into alleged fraud by the Trump Organization. Trump defiantly invoked his Fifth Amendment rights against self-incrimination, a move he had once disparaged.
You see, the mob takes the Fifth. If you're innocent, why are you taking the Fifth Amendment?
Trump's deposition is the latest chapter in a contentious standoff with New York's Attorney General Tish James.
Former President Donald Trump invoked his Fifth Amendment rights today, choosing not to respond to questions from New York's Attorney General. This deposition is part of a long-running civil investigation into alleged fraud involving the Trump Organization. Interestingly, the situation is somewhat ironic, considering Trump has previously criticized others for taking the Fifth. Trump has a reputation for being defiant, and today was no exception. Now, imagine you're a judge overseeing a major financial fraud investigation. You have mountains of evidence, documents, witnesses, and records, but one crucial piece is missing. You need to question the central figure involved about his actions and knowledge. So, you issue a legal summons requiring him to appear and answer questions under oath. If he refuses, there will be consequences. Instead of cooperating, this individual pushes back. He hires a team of high-priced lawyers who file motion after motion attempting to block the subpoena. They argue that he's too important to be questioned, claiming immunity from testifying and insisting the investigation is politically motivated. They throw everything at the wall, hoping something sticks. But the judge isn't convinced. You're not special, the judge rules. You have to answer questions like anyone else. Eventually, the appeals run out. With no options left, the individual is forced to appear for the deposition. Investigators arrive fully prepared, armed with hundreds of questions and stacks of supporting documents, ready to finally get answers. But once he sits down in front of the cameras, he simply says, "I invoke my Fifth Amendment right against self-incrimination." For hours, every time he's asked a question, he gives the same response, again and again, hundreds of times. Technically, he's complying with the summons by showing up, but he provides no useful information. Investigators are frustrated, and the judge is clearly irritated. In the end, he walks away having completely stonewalled the process. That's exactly what happened with Donald Trump. Across multiple cases, judges ordered Trump to testify. He resisted for as long as possible, dragging out the process with legal challenges. But eventually, he ran out of road and had to show up. When he did, he invoked the Fifth Amendment and refused to answer any substantive questions. The most notable instance occurred during the New York civil fraud investigation led by Attorney General Letitia James. Her office was examining whether Trump had inflated property values to obtain better loan terms while deflating those same values to reduce taxes. To get answers, James subpoenaed Trump to testify under oath. Trump's legal team immediately pushed back, arguing that answering questions in a civil case could harm him in potential criminal investigations. They deployed every legal tactic possible to avoid the deposition. But the judge rejected those arguments, ruling that Trump's claims of immunity and privilege did not apply. James had every right to question him under oath. Ultimately, in August 2022, Trump appeared for the deposition. Once again, he invoked the Fifth Amendment in response to nearly every significant question. Invoking the Fifth is, of course, a constitutional right. No one can be forced to testify against themselves. However, there's an important distinction in civil cases. Unlike criminal trials, juries are allowed to draw negative inferences when someone refuses to answer questions. In other words, jurors may reasonably assume that if the witness had a favorable answer, they would have provided it. By declining to answer hundreds of questions, Trump arguably left the impression that he didn't have good answers to give. Legally speaking, invoking the Fifth does not prove guilt, but does raise eyebrows. It fuels suspicion and invites scrutiny. And in Trump's case, it reinforced the perception that he may have something to hide. Today, I'm breaking down Trump's repeated strategy of avoiding testimony, examining the cases where judges ordered him to appear, what happened when he invoked the Fifth, and why this approach continues to work for him, even as it leaves many people shaking their heads. Trump has learned how to walk a legal tightrope. He can't ignore a judge's order without risking contempt, but he can show up and refuse to cooperate, protected by the Fifth Amendment. Prosecutors and judges can't force someone to incriminate themselves, even when it's painfully obvious that the person is stalling. We'll start with the New York civil fraud case, the most high-profile example of Trump being compelled to testify and then refusing to answer. The investigation began in 2019 when Attorney General Letitia James launched a probe into Trump's business practices. Her office examined whether the Trump Organization systematically inflated asset values to secure loans and insurance, while deflating those same values to lower tax liabilities. If you tell a bank a property is worth $500 million, but tell tax authorities it's worth only $50 million, that's misleading at best and potentially fraudulent if done repeatedly. James gathered documents, interviewed witnesses, and analyzed financial records. What she found raised serious concerns. Asset valuations appeared to shift depending on the audience. To fully understand who was responsible, she needed Trump himself to explain the numbers, identify who prepared the statements, and clarify his role in the process. That's why, in December 2021, subpoenas were issued compelling his testimony under oath.
CBS News legal analyst Ricky Kleeman.
Any lawyer worth his or her salt would have told Donald Trump that it was essential for him to invoke his Fifth Amendment privilege at that deposition today.
The New York Attorney General's office said today it will continue to pursue the facts and the law wherever they may lead. Our investigation continues. This comes as new details emerge about the FBI search of Trump's Florida home. Agents spent 9 hours in the residence and searched an office. There are other Trump-related investigations, a criminal inquiry by the Manhattan District Attorney into his businesses here.
A legal expert later weighed in, stating, any competent lawyer would have advised Trump to invoke his Fifth Amendment rights during that deposition. Meanwhile, Attorney General Letitia James's office made it clear they were not backing down. They remained committed to uncovering the truth, wherever it might lead. All of this unfolded against the backdrop of several other investigations, including a lengthy 9-hour FBI search of Trump's Florida residence. And Trump wasn't the only one under scrutiny. His adult children, Donald Trump Jr. and Ivanka Trump, were also subpoenaed and required to testify under oath. Naturally, Trump did not accept this quietly. His legal team immediately moved to quash the subpoenas, arguing that overlapping criminal investigations could use testimony from the civil case against him. They claimed Trump was being forced into an impossible position: either defend himself in the civil matter or risk incriminating himself in a potential criminal case. Based on that reasoning, they argued the entire proceeding should be dismissed. A New York Supreme Court judge was not persuaded. In February 2022, the judge ruled that Attorney General James had every right to question Trump and his children under oath. The court emphasized that the existence of a criminal investigation does not excuse someone from testifying in a civil case. While Trump was free to invoke the Fifth Amendment in response to specific questions that could lead to self-incrimination, he could not refuse to appear altogether. The judge ordered Trump to comply. Trump appealed. When that failed, he appealed again. Each time, the courts rejected his arguments. By August 2022, Trump had exhausted all legal avenues and was forced to sit for a deposition with the New York Attorney General's office. But Trump arrived with a plan. Just before the deposition began, he released a public statement declaring that he would not answer any questions and would instead exercise his constitutional rights. This framing was deliberate. Rather than appearing to dodge the investigation, Trump positioned himself as a defender of constitutional liberties. When questioning began, reports from inside the room indicated that Trump invoked the Fifth Amendment more than 400 times. This wasn't limited to a handful of sensitive questions. It was his response to nearly every meaningful inquiry. Questions about financial statements, specific properties, internal decision-making, meetings with accountants, and his role in the Trump Organization were all met with the same reply: I invoke my Fifth Amendment right against self-incrimination. For hours, Trump sat for the deposition, physically present but entirely uncooperative, using the Fifth Amendment as a shield against providing any information that could assist the investigation. Legally, he was within his rights. The Fifth Amendment protects individuals from being forced to incriminate themselves. If Trump genuinely believed that answering questions about his business practices could expose him to criminal liability, he was entitled to remain silent. However, invoking the Fifth in a civil case carries consequences. In civil proceedings, unlike criminal trials, juries and judges are permitted to draw negative inferences from a party's refusal to testify. Most innocent people can simply explain their actions. If no fraud occurred, Trump could have clarified that the valuations were based on legitimate appraisals, accounting judgments, or good faith differences of opinion. Instead, by refusing to answer hundreds of questions, he created the impression that truthful answers might have been damaging. That impression mattered. During the New York civil fraud trial, Judge Arthur Engoron explicitly noted Trump's repeated invocation of the Fifth Amendment. Combined with the documentary evidence and witness testimony, Trump's silence strengthened the Attorney General's case. Ultimately, the court found Trump liable for fraud and imposed a civil penalty of approximately $354 million. This was not an isolated incident. In a separate Bronx case, protesters alleged they were assaulted by Trump's security team and filed a civil lawsuit seeking testimony about Trump's security operations and instructions. Trump's attorneys argued that, as president, he should not be subject to civil subpoenas and was too busy running the country to sit for depositions. The judge rejected that argument, ruling that being president does not grant immunity from civil litigation, particularly for actions that occurred before taking office. Trump was ordered to appear. He complied, but only after resistance. During the deposition, he adopted a combative tone, challenged questions, and avoided giving direct answers whenever possible. This pattern extends beyond civil litigation. In congressional investigations, Trump has repeatedly resisted subpoenas, asserted executive privilege, filed lawsuits, and instructed aides not to cooperate. When courts rule against him, he appeals. When appeals fail, he looks for new ways to delay or limit compliance. The strategy is consistent. Drag the process out as long as possible. If compliance becomes unavoidable, provide the bare minimum while avoiding substantive cooperation. To many observers, this behavior appears baffling and even incriminating. But Trump's supporters interpret it differently. They view his refusal to cooperate as a principled stand against what they believe is a corrupt, politically motivated system. In their eyes, these investigations are witch hunts, and Trump's resistance is courageous defiance. Trump actively reinforces this narrative. He repeatedly claims he is unfairly targeted and that the investigations are hoaxes. This messaging resonates with his base, shaping their perception of his legal battles as persecution rather than accountability. For others, the situation is deeply frustrating. It feels as though Trump operates above the law, able to dodge subpoenas, stonewall investigations, and delay consequences. While judges have rejected his claims of immunity and forced him to appear, they cannot compel him to speak once he invokes the Fifth Amendment. Even after losing the New York fraud case and facing a massive financial penalty, Trump has appealed. The appeals process could take years. And even if the judgment stands, Trump, by his own claims a billionaire, can likely absorb the financial hit without personal ruin. Meanwhile, he remains politically influential and continues to pursue another presidential run. This raises a broader concern about how the legal system handles wealthy and powerful defendants. With enough money, elite legal representation, and endless appeals, accountability can be delayed for years. Litigation becomes a war of attrition, one that favors those with the deepest pockets. Trump has refined this strategy over decades. He has been sued thousands of times in his business career and learned that making litigation expensive and exhausting often leads opponents to settle or give up. He now applies the same approach to political and legal challenges. The Fifth Amendment is a legitimate constitutional protection, but it has limits. While it can prevent compelled self-incrimination, it does not block the use of documents, witness testimony, or other independent evidence. Judges can still draw adverse inferences, impose sanctions, deny delays, and build records that reflect a pattern of obstruction. And while Trump's tactics may buy time, they do not guarantee immunity. He has already lost significant cases, faces additional legal exposure, and may eventually encounter the limits of delay and deflection. Trump's approach reveals how someone with immense resources can navigate the legal system, not by complying in good faith, but by exploiting every procedural safeguard available. Whether that strategy ultimately succeeds remains to be seen. That's all for today. If you made it this far, consider subscribing, liking, and sharing this with someone who wants to understand Trump's legal strategy. Breaking down the law helps clarify what's really happening here. Not just defiance, but a calculated plan built on constitutional rights, aggressive lawyering, and delay. I'll keep breaking it down. No fluff, just the facts, the law, and what it all means. Catch you in the next update.